Hello, everyone, and welcome to the first impression and also uh, general discussion on GS Paper 2 2025, the paper which was held just this evening, 2:30 to 5:30. We'll discuss the questions that came from polity, governance, and of course from IR. So let's begin. So we had questions that this year were not that easy, I would say. And we did have some concerns regarding certain questions. The difficulty level was extremely high this year for a lot of questions. So without much delay, let's begin. So first question, it says, discuss the corrupt practices for the purpose of RPA 1951 and also analyze whether the increase in the assets of the legislators and of course or their associates disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. Interesting question. Though, to be very frank, we have had a lot of questions from RPA 51 in the past, and especially from the section of not qualifications, but rather disqualifications, right? So we have primarily had questions from disqualifications, and this is one such question from disqualification. Now, the very first reason why this question was asked, very important for us to understand, is the fact that, see, we are looking into a lot of electoral reform debates going on right now. For example, the rising concerns about the use of, money power in the elections, the use of muscle power in the elections, and also we have this ADR, Association for Democratic Reforms, which consistently flags these asset jumps of these legislators, right? In fact, various judgments, like say the Lily Thomas case, the very famous Lily Thomas case of the year 2013, or the Lok Prahari case of 2018. So these two very interesting judgments have also ensured decriminalization of politics, and it has tried to address this issue of criminalization of politics and also the disproportionate asset monitoring, meaning assets which are not in proportion to your known sources of income. In fact, in Supreme Court's 2018 Lok Prahari judgment, it also had mandated that the candidates and their spouse, dependents, they also need to disclose the source of income. So directly linking the asset transparency to something called, say, electoral integrity, right? And of course, we have this current demand going on for stronger mechanisms to curb black money in elections, right? We need to ensure level playing field, and also the concern of concentration of wealth in politics. So I would give this question a rating of anywhere from 7.5 to 8 on the difficulty metric, because it was a difficult question. Why? Because number one, it requires you to also have information on RPA 1951. That's the very first requirement. And not just RP 151 as a general overview, but on corrupt practices mentioned under section 123 specifically, right? Then you also have to have this analytical skill to connect the traditional corrupt practice definitions with the contemporary gray areas. Then you have to also use some judicial interpretation awareness, linking this concept of disproportionate assets to what we know as undue influence. So yes, it was a difficult question to address, and so we'll have to start by mentioning about, of course, what exactly is the corrupt practice, and then the idea that corrupt practices or RPA 51 is the cornerstone legislation for free and fair elections, and then the sections that are mentioned there, section that is 123, and the subsections like, say, bribery, gifts and offers and promise by the candidate, by the agent, undue influence, right? Direct or indirect interference with the free exercise of electoral rights, things like threats, intimidation. In fact, social ostracism is also included. Then things like religious communal appeals, false statements, hiring vehicle without permission, excessive expenditure beyond the prescribed limit, and the very infamous use of government machinery. Remember, this was the subsection under which Indira Gandhi was disqualified by the Allahabad High Court. And then in the second part, you'll have to mention the disproportionate assets analysis. So what are the arguments as to why it should be considered something as an, should we say, a corrupt practice? Of course, is the Supreme Court's judgment. So you had to have awareness on this judgment. Beyond that, voters' right to information is important. A very famous case of 2003, the People's Union for Civil Liberties, it also had talked about the same concept, right? The voter has a right to know. Asset disclosures enable information for voters. It also enables electoral choice. Then, of course, it is also indirect electoral interference. See, unexplained wealth creates unequal playing field. When I say free and fair elections, of course, freedom to vote. The voting is completely free. When you enter the polling booth, you are free to choose for a vote for any candidate. But is it fair? Do people have equal chance of winning? So when you have disproportionate assets, of course, the real concern is that it is unequal wealth, creating unequal level playing field or unequal playing field, which will influence the voter perception, more ads. And think of it, it also goes on to directly attack 39C, the very famous DPSP, right? Remember, 39C talks about how the concentration of wealth has to be reduced. So it violates the constitutional mandate as well. Now, see, when you talk about any argument against, because you have to analyze, so do you think that known sources of income should also be a part of undue influence and a corrupt practice? So you can say that, see, the legal interpretation has to be very narrow. When we say the traditional idea of what is meant by undue influence, what does it mean? It focuses on the direct voter threat, not asset ownership. If you go through the exact definition of section 123, it does not mention really these things. So that's a concern. And disproportionate assets are actually covered separately under a law called Prevention of Corruption Act 1988, a very famous law under which a lot of civil servants and public servants do end up in jail. No, they don't end up in jail, but cases can be filed, right? That's one concern, that we do have a separate law to deal with this. Then why this overlap? And people also say that, see, if you have an increase in assets, it does not really directly constitute interference with this free exercise of electoral right. That's also a concern. And then it's also very difficult, to have a clear-cut link between asset growth and the electoral misconduct. So yes, we have our pros, we have our arguments against. So finally, if you talk about the judicial evolution, the earlier position was that asset disclosure is sufficient for transparency. Now the current trend is that the courts are moving towards treating non-disclosure as a corrupt practice. Okay, and maybe possibly we can have some kind of a permanent monitoring committee or mechanism in future, right? So yes, this is all that you had to mention here. And if I have to point out what challenges would any aspirant face, of course, the very first challenge is the recall value. This has a very high recall problem because you needed to remember the examples under section 123 and then some legal definitions of bribery, undue influence, and also a link to Prevention of Corruption Act as a law. Then, of course, we need to also clarify the technical word disproportionate assets. It does also require some kind of hypothetical reasoning, because there is no direct precedent on assets that increase as undue influence. So that's also a concern. So we had to also talk about the advantage as to why, if you have disproportionate assets, how does that relate to interference, or why not? Both cases. Then also integrating some examples of Lily Thomas case, PUCL case, Lok Prehri case. So yes, managing time, and these are all 10 marker questions, mind you. So managing time and all such things would be a challenge, right? So yes, so we have to ensure now, once you see such questions, that see, this is a conceptual question, applied law question. It tests both your statutory knowledge of RP provisions, of course, and also the ability to analyze the contemporary electoral challenges through the existing legal framework. That's also there. So yes, overall, a difficult question to answer because it had two parts. You had to mug up some information and present on paper. Plus, you also had to ensure that you analyze the consequences of it, right? So this was the very first question. An aspirant looking at this as the first question will, of course, become extremely nervous as to what could the other questions be. But anyway, I mean, to be very frank, all aspirants would know, I've been telling this in the class consistently, that RP and especially disqualification is very important. I mean, not just me, any faculty who takes polity, governance, etc. would have told this to you. And now the burden is on you to revise. So see, my point is to tell you that it's very important to understand the previous year questions, the trend, and then focus on those selective points rather than randomly mugging up facts from RPA, right? So you see how the UPSC has consistently been telling us that, see, these are areas where you need to focus on, and we will ask questions from these areas. So we have to have a slightly smarter strategy of preparation. Okay, next question. Comment on the need of administrative tribunals as compared to the court system. Assess the impact of the recent tribunal reforms through rationalization of tribunals made in 2021. So I would say again, why was this question asked? Very simple. We had this Tribunal Reforms Act of 2021, though sadly the matter is still pending in the court, right? So the very famous Madras Bar Association case of 2021, where Supreme Court did strike down certain provisions of the ordinance with respect to the age cutoff criteria, etc. But then the parliament brought the government brought the bill again, got it passed by the parliament. It's pending in the Supreme Court. So yes, through the Tribunal Reforms Act, the parliament or the government has abolished 9 appellate bodies, including bodies like FCAT, the AAT, the Authority for Advanced Rulings, etc. And although the functioning or all the cases pending in front of all these tribunals, they have been transferred to the respective high courts. Then, of course, we have to also mention the Madras Bar Association judgment. So that's also one reason for asking this question. The case is still pending in the Supreme Court, which is a very unique factor. Normally, when judgments are done, then questions are asked, but it's a pending case. And then this never-ending debate of tribunalization of judiciary. So that's also there, where tribunals are constantly reducing judicial pendency, but at the cost of, say, parallel courts, right? So that's also there. So again, what do you need to do, or need to at least know? You have to know the concept of administrative tribunals, which is mentioned under which article? 323 capital A, right? Then we have to also compare between tribunals, the advantages of tribunals compared to or vis-a-vis the ordinary court system. And then, of course, some current affairs integration. I would not say current affairs, I would say contemporary events, because this is a case of 2021. So see how we have to understand contemporary events. Again, covered in the classes properly, effectively. So any informed aspirant could have written this answer. So you can start again by writing about what are tribunals. Simplest possible way to introduce such things is talking about how tribunals were added as a concept through the 42nd Amendment Act in 1976, empowering the parliament in the states to create tribunals in general, and only the parliament to create tribunals on what matters? Administrative matters. Then mention that. And then you have to mention advantages of tribunals. What are the advantages of tribunals that we see? As far as the advantages are concerned, of course, you can mention things like specialization, speedy justice, reducing pendency, though sadly, we see a lot of pending cases in the tribunals as well. But still, then it's cost effective, it is accessible, it provides for domain expertise, right? And what can be a court system advantage? Again, independence is what the courts have, which tribunals don't have, sadly, because of excessive government interference and control. Then comprehensive jurisdiction. There is a concept of presidential value. Public confidence in judiciary is very high. And then some issues with the tribunal system, like vacancies, etc. Right? Appeals, of course, tribunal judgments or awards are appealed in High Court and Supreme Court. So that's also a concern. Then lack of infrastructure. So all these need to be covered. And then, of course, the current affairs part, the Tribunal Reforms Act 2021. What was the rationalization? Meaning you have to mention how the 9 bodies were abolished, how the functions were transferred, and then we had a standardized framework through what? Something called the Search Cum Selection Committee, SCSC, right? That's the new framework to appoint the members of tribunals. And then we have also had some modification in the tenures. So tenure has been modified. That's also there. So modification of tenure has been done, reduced to 4 years. We have the minimum age criteria now, a restrictive qualification of 50 years. So all these things are there which need to be mentioned. Also mentioning the rationale of the government, right? The government's logic was that we need to abolish certain tribunals. Why? Because it will reduce the cost, number one. It also eliminates this idea of redundancy, right? Many tribunals are unable to provide speedy justice because of excessive workload, and also provides for something called administrative efficiency. So the positive impact, like resource optimization, burden transfer to high court, that would be a negative impact, I would say. A duplication rather would be a positive impact, right? Then the appeal structure becomes more clear now. Cost saving. One big problem is the burden transfer to high courts, right? So that's there. Loss of specialization, because the advantage of a tribunal was specialization. And yes, we have to also mention the Madras Bar Association judgment, right? So yes, and in the conclusion, when talk about the need for reform, of course we can't abolish, but we need to reform. We have to strengthen the tribunals with independence, adequate staffing, jurisdictional clarity, funding, etc. Have a balanced approach, administrative efficiency without compromising on judicial independence. That's the idea. Okay, so that's what you need to write as an aspirant. I would say this question was anywhere from 5 to 6. Why I say 5 to 6 is because this is pretty standard as information. Nothing out of the ordinary has been asked, right? Yes, we have to ensure balanced treatment and time allocation, proper weightage, and structural coherence. These are things that need to be followed in such questions, because you don't have to just overburden the answer with the benefits and the reasons and the need for tribunals, what are the challenges facing or plaguing the tribunals, and completely forget about this, because ultimately this is just a 150-word answer. So the allocation of words has to be very, very proper, right? So that is, I think, the only concern here, that you know a lot of information, you have to use arrows and flowcharts to explain all the ideas, advantages, need, etc. So that's there. Okay, so see, this question I would say is a classic polity, current affairs, governance, integration question. It will test your theoretical knowledge, also the practical awareness of what exactly is going on, what reforms are being performed by the government, etc. So not really a difficult question for any informed aspirant, right? So after the first question, it was a welcome relief, I would say, to see such a question. Okay, now let's move on to the third question. Compare and contrast the president's power to pardon in India and in the USA. Are there any limits to it in both the countries? What are the preemptive pardons? Okay. So again, why this question? I would say in USA, this issue that happened, Joe Biden's pardon of Hunter Biden, full and unconditional pardon for tax evasion, gun charges, that sparked debate on the ethical limit of president's clemency in USA, right? In fact, Joe Biden had been considering preemptive pardon for allies like Kamala Harris, Dr. Fauci, who was it? Liz Cheney, I think Liz Cheney, yes. So all these people. So preemptive pardons were being considered. So possibly, and yes, in India also, pardoning powers were being questioned, though not exactly pardoning powers, But these remission powers of the governments were being questioned in the Bilkis Bano case. So in both these countries, these powers to forgive and forget, move on, giving convicts a second chance was being questioned because it did not seem to be fair. So possibly this could be a reason. Otherwise, the question is not that difficult. It just needs you to know basic information on President's pardon in India and USA and just preemptive pardon. So see, first up, you simply compare. Both presidents enjoy the clemency powers, executive domain. This is separate from judiciary. As we say, this is not a judicial power. It is a separate independent power of the Indian president. Of course, in our country, let's say in India, you could have drawn rather a table to compare India with the US president. So in India, of course, under Article 72, but let's not forget, this is to be performed on the advice of Council of Ministers, whereas in USA, it is a full discretion of the US president. Of course, that's how the country functions, because USA is a presidential form of government, right? And in USA, the president's power is for federal crimes only, because it excludes the state crimes, right? If you remember, USA, the states have their own constitution, unlike in India. That's not the case in India. Union laws, court martial, death sentence, everything is covered. Okay. In India, we do have concepts of pardon, complete absolution. In USA, punishments are removed, the conviction records remain. In India, judicial review is also allowed, though limited, like the E. Sudhakar case, very famous. And in USA, there is almost negligible judicial review as far as US president's pardoning power is concerned, right? They have that mentioned under Article 2 of their constitution. That's there. See, one interesting aspect of this question was, what is preemptive pardon, right? So preemptive pardon is pardoning for a crime uh, which has been committed, but before the conviction or trial. Crime has happened, but the conviction or trial has not taken place. In India, we don't have this concept. So India does not recognize preemptive pardons. For example, if you look at Article 72 or say even the governor's power of Article 161, these apply only in those cases where what? Only in those cases where a person has been convicted of an offense, right? So until conviction, there is no punishment. So what will you remit? What will you commute? What will you pardon, right? A pardon is a relief from a sentence, a penalty, a punishment. It's not a way to prevent prosecution itself. That's what we follow. Contrast it to say a country like USA. In USA, you have this concept where the president can issue preemptive pardons, forgive offenses that have been committed, but not yet prosecuted or even charged. The very famous case of Gerald Ford pardoning Richard Nixon. So there was this Watergate scandal. If you want to know more on the Watergate scandal, if you don't already know, I think you should watch that movie. What is that movie? Very famous movie on this, All the President's Men. Yes. So this is movie in 1976, All the President's Men, starring Robert Redford and Dustin Hoffman, directed by Pakula. Pakula also made this movie called Sophie's Choice. Anyway, let's not digress. So in the Watergate scandal, what exactly happened? Nixon had to resign, right, in 1974, fearing impeachment and then criminal charges. A month later, when Gerald Ford was in power, he issued a full, free, and as we say, absolute pardon for Nixon, which covered all the offenses he has committed or may have committed. No, interestingly, Nixon had not been formally charged for the crimes that he had committed. But Gerald Ford pardoned him, or should we say, ordered preemptive pardon. In fact, it was very, very controversial. In fact, Gerald Ford's popularity and ratings nosedived immediately after this decision. And people say that his loss in the elections in 1976 can be largely attributed to this kind of preemptive pardon. But then, you know what? Later historians also said that, see, it helped USA move past the Watergate scandal. But anyway, that's for USA to decide on what they want to do. Or a very famous case was of Jimmy Carter's pardoning of the Vietnam draft evaders. So during the Vietnam War, as you know, 1960s, 70s, around 2 lakh young Americans had evaded the draft. Drafting meaning military conscription, mandatory military conscription. A lot of them went to Canada, or should we say, fled to Canada. So on his very first day in office, that is 21st of January, 20th is the oath ceremony for the US president. On the 21st of January 1977, 76, 77, President Jimmy Carter issued a blanket pardon for all the draft dodgers. So it was like, the idea of national healing, because the war was extremely divisive. Anyway, USA has largely lost all wars that it has tried to be a part of outside its country. So yes, and once all these people who escaped and fled, who had shown no interest to serve the armed forces in the army, they finally could get back. Right, it brought back thousands and thousands of exiles. So yes, this was the question. Again, I would say not a very challenging question. Maybe if you could get an idea of what is preemptive pardon, maybe around a 6 or 6.5 on the difficulty scale, medium difficulty, I would say. But as an aspirant, what challenge would you face? Of course, you have to be precise with the articles, with the definition, then some current affairs context, maybe Biden's pardoning power, the Bilkis Bano problem in India, right? And yes, you have to also know what is meant by preemptive pardons, which is not a concept in India, right? So becomes extremely challenging to know such phrases. So the only way was to know it through the meaning of this word preemptive pardon, right? That's there. So yes, again, a healthy mix of static information and current events, right? Okay, let's move on to the next question. Discuss the nature of Jammu and Kashmir Legislative Assembly after the J&K Reorganization Act. So after the J&K Reorganization Act, we had to discuss the nature of J&K Assembly and briefly describe the powers and functions of the Assembly of UT of J&K. I mean, you cannot get a more straightforward question in the main exam than this, right? Simple. We have had the Reorganization Act passed in 2019 for Jammu and Kashmir, right? And though problems still persist, a lot of POJK, I mean, we still have a lot of Jammu and Kashmir as a part of Pakistan. They have occupied it illegally, but still, whatever remains is under our control. And J&K has a UT, though we have seen a lot of demands, right, from especially the CM there. In fact, if the real concern for the CM there is that he does not have the police power, right, just like in Delhi. So Delhi CMs don't enjoy police power. So he has been hellbent on getting back that authority, that power. So the restoration of statehood demands keep on coming from there. Anyway, so we'll have to have the Supreme Court for the UT of Jammu and Kashmir. So a lot of current context there for us to somehow get to know that this possibly could be a question in the exam, right? And then we constantly see, as I said, the CM's demand coming up that we want our statehood to be restored. In fact, he has tried to praise the prime minister as well, hoping that the statehood demand will be restored. But just recently, Supreme Court has also asked the center to respond, but Supreme Court did say that, see, the conditions don't really permit restoration of statehood demand, especially after what happened in the Pahalgam terror attack, where more than 24 people were killed, massacred, right? So, and in the name of religion, right? Whether you would want to agree or not, but that was a fact, sadly, right? So we still have to have some kind of control. Central control is required. We cannot give up the policing powers so quickly. That was the court's observation as well, right? Anyway, so coming back to this question, simple, straightforward, plenty of discussions along the lines of statehood restoration for Jammu and Kashmir, which would force any aspirant to mug up these points, right? So beyond that, you have to talk about what? You have to talk about the nature of the assembly. After the reorganization, how you have a UT with legislature, then you have a single legislature. So earlier, JNK also had a council, 36-seat council. It has been abolished now. Then now we have the tenure of 5 years. Then we have this typical model structure where LG will be the head with the elected government functioning within the UT framework restrictions. Then you have legislative parts. State's jurisdiction has been controlled, especially with respect to police, public order, right? That's again a big concern. So yes, you'll have to mention these things, executive functions. You'll have to mention how assembly exercises control over the Council of Ministers through vote of no confidence, etc. They have financial powers, budget passage powers. The same kind of administrative oversight is also available. So these things might not really, we can just mention these words that they follow a similar structure as to what is there in other places with certain differences, right? So again, as I would say, I think this was somewhere around 4 or 5 in the difficulty level, not at all difficult. You just had to mention plain, simple facts, right? And yes, the only point would be you have to have a balanced approach. Don't write things that might not reflect well, that might reveal your stand, that no, Kashmir statehood must be restored at the earliest. No, concluding remark has to be very, very carefully managed here. So, based on conditions and circumstances, we cannot simply restore statehood demand with killings happening in this with this frequency and at this scale. So we have to carefully weigh into all these aspects, right? And then only can the statehood demand be restored. So we can maybe have a conclusion along these lines. So it's very important to have a balanced approach, because this could end up in an ideological drift. You might end up in a political debate mode, and that could jeopardize the scoring here. Okay. So this was again a question. Now let's move on to the next question. The Attorney General of India plays a crucial role in guiding the legal framework of union government and ensuring sound governance through legal counsel. I mean, straightforward. Discuss responsibilities, rights, and limitations in this regard. I mean, I need not tell you. If you refer to the notes, you'll get to know functions, responsibilities, support role, and limitations. All were mentioned separately. Simple, straightforward. I don't think I can mark this on a difficulty level of more than 5. This is as straightforward a question as it can be, right? Now, see, we have had a lot of high-profile cases where AG has been a part of it, right? Article 370 abrogation, Delhi government versus LG electoral bond issue, right? Then we have also seen how Attorney General's role comes into picture when it comes with respect to contempt of court proceedings. I hope you are aware that under the Contempt of Court Act 1971, AG has this exceptional power, extra authority to provide for permission to commoners to file a case of contempt in the court. And I mean, we did have an appointment of the new Attorney General in 2022, but that's far-fetched. I don't think that really matters. But yes, otherwise, you have to just know the provisions. Which two articles? Article 76, Article 88, two clear-cut provisions that needed to be incorporated, their functions, duties, restrictions, right? And maybe in the concluding remark, you can mention about the independence and loyalty debate that always takes place, right? Because the Attorney General is the lawyer of the government of India. He's not the lawyer of the ruling party, right? So that could be your concluding remark. In fact, a 2019 question was along similar lines. So talk about the constitutional framework, etc., and then mention these 3 aspects. So nothing difficult here, I would say, nothing unique to write. Simple, straightforward question. The only concern any aspirant would face was maybe you did not remember all the points, right? Because when you have to mention functions and rights and limitations, you can't say good functions, nice functions. You have to mention those functions, those exact limitations. Be it limitation of, say, not taking up a case against the government of India, or something as simple as any kind of matter that is filed by any government department, it must come from the department or Ministry of Law. So if I am an IAS officer and I want AG's help, I cannot directly approach him. I have to make a representation through the Ministry of Law. That's also a limitation. So any of these limitations and every of these limitations had to be incorporated, right? That's it. So not a difficult question to address. So a healthy mix of some easy, some difficult questions so far. Okay, next one, a question on governance, e-governance. E-governance projects have a built-in bias towards technology and backend integration than user-centric designs. Examine. Again, see, so we have had this entire concept of digital India, and frankly, the impact has been very mixed. Some initiative like, see, DigiLocker, right, Coven, right? So some initiatives that you have seen, MyGov. So all those who are not using it can use this, access this website. It's a very interactive model-based website. Then Aadhaar-enabled services. So it has shown India's rapid, I would say, digitization capabilities. But then uh, one criticism that we did experience, especially in the COVID-19, was that COVID vaccination platform was seen as being tech heavy, but it lacked accessibility for the poor people, especially for rural people, and also digitally illiterate population. That's there. We have had parliamentary committee reports also mentioning continuously of this digital barrier, digital divide. So digital barrier has been, or I would say digital divide has been the major concern as far as e-governance is concerned, through or rather the delivery of services is concerned via e-governance. So that's been there. Beyond that, I don't see any major concern. You have to talk about the e-governance theory understanding, the G2C model, G2B model, G2G model. We have seen all these aspects. Awareness of some India-specific digital divide issues, some accessibility challenges also. So talk about the e-governance projects. What is e-governance? That is use of ICT in government processes. And then how does it have a built-in bias? A built-in bias towards technology. So the focus, as I said, as the question also says, is on the backend integration, Aadhaar seeding, for example. So priority is on the biometric integration, right? Rather than the user interface simplification. The India stack architecture, right? Emphasis is on the API layers, data interoperability, system integration. In the performance metrics, you see success is measured by the technical statistics rather than citizen adoption rates. And if you also just go through the NESDA, the National E-Governance Service Delivery Assessment reports, you will realize that citizen awareness is the biggest concern, or rather lack of awareness is the bigger concern. But we are focusing more on, now 5 more services have been rolled out for citizens on e-governance platform. I mean, you have to also see the adoption rate of citizens, right? Is the service being used by larger chunk, or is the same group of small group of elite digitally literate people who are constantly using everything? So that's again a huge challenge, right? And then of course multiple overlapping portals, BharatNet, Umang, CSC, the common service centers, they have been created, I would say, without any unified design thinking. Okay. And then of course you have to mention on the lack of user centric designs also separately as a heading. We have accessibility gaps, infrastructure gaps, poor internet connectivity, smartphone penetration limiting access. And again, you can quote there also the UN DESA, the e-governance index by the United Nations, right? So there also, amongst the 3 metrics or parameters, the poorest that we fare is in telecommunication infrastructure index, TII, right? So that's also concern. So they have 3 metrics: online service index, the human capacity or capability index, and the telecommunication infrastructure index. And this is where we are lagging behind the most compared to amongst all these 3, which pushes our rank to beyond 90s, right? So it is very clear, infrastructure barriers are there. Okay, digital literacy deficit is there. Platform designs are meant for tech savvy people. Low literacy population has been ignored comprehensively. You have language barriers, right? Predominantly English interface everywhere. Of course, India has huge linguistic diversity, right? Look at the Covin app. I don't need to tell you how the people from urban areas would book the slots meant for rural areas and go and get vaccinated, whereas the rural population had no clue about it. Okay, eBhumi, for example, the interface is extremely complex, incomprehensible for rural farmer. I mean, rural farmer is a primary user, but the website seems to be highly tech heavy, right? Then a lot of government websites, they are non-mobile friendly, right? Broken links, expired security certificates. I mean, sometime in the classes as well, when we try to just show certain websites, the website is not working. So that's there. And then you can also add an aspect of what can be a possible consequence of this kind of bias. Rural exclusion, demographic marginalization, as I would say, a lot of dependence on the intermediary, all these things. Resource waste, frankly, that's also there. Towards the end, let's also add the idea of reform. So once you add reform as the idea, then it comprehensively completes the question. Design thinking approach, right? Citizen-centric design, simple, multilingual, mobile-first interface, that should be prioritized, right? Then user testing integration, mandatory usability tests before you roll out anything. It is very important. Okay, testing. Then inclusive design principles, right? Designing for diverse capabilities, including disabilities, low literacy, as I said, language preference, etc. So this is how you conclude the answer. Again, I don't see that as this question as a huge concern, pretty straightforward, though the words could have been slightly complicated. But again, the basic challenges that e-governance faces is what you had to mention here as well, right? So nothing much. The only concern would be fitting all your points in 150 words, right? So that's one thing, and we don't have to also, analyze it with just a singular point agenda. We need to also have a more comprehensive approach of analysis and adding reforms, even though they don't ask, but we should summarize our answer with some reform, because the word limit pressure will be there. Okay, on this. Okay, so as I said, I mean, I would say a very simple way to test whether the aspirant can critically evaluate the Digital India initiative or not, beyond the tech glorification, as we say. You have to focus on inclusiveness. You have to focus on citizen experience, which is very, very essential for future administrators, right? Because the idea is that you should, so the technology should serve all citizens, not just the digitally privileged people, right? So that's it. Next would be the questions, 10 markers from IR. So India Africa digital partnership is achieving mutual respect, co-development, and long-term institutional partnership. Elaborate. So I think this is a question that that does not require a lot of understanding of why it was asked. We had recently in the Africa Day also, they had a lot of focus on digital transformation, because that's the key to the socio-economic growth, is what they said. Then we have also seen this, like we have the digital public infrastructure model. So they have this African Union's DTS, Digital Transformation Strategy 2020-30, that is there. And then we have the India Africa Forum Summit. We have also had a lot of cases. I think recently some IIT Madras or Powai, I'm not sure. It had this that IIT Madras or IIT Powai Zanzibar campus was there. UPI integration with Ghana has been seen. UPI integration with Namibia has been done. And of course, India is also positioning itself as an inclusive alternative to what China has, the Belt and Road Initiative in Africa. So in that context, not too difficult. So knowledge of the basic DPI components of India, like say Aadhaar. In our country, Aadhaar, UPI, Diksha, Kovin, also mentioning understanding of the priorities of African countries, what their digital priorities are, ideas of connectivity, that is their priority, ID systems, payments, right, education. So linkage there. And some kind of bilateral projects awareness might be required. As I said, the UPI integration one would be that IT Zanzibar this awareness project awareness. That's it. So nothing beyond this, right? Mutual respect, meaning demand driven, equal partnership, voluntary adoption, right? A lot of African countries have voluntarily adopted. It has not been imposed, be it Ghana, Namibia, Zambia, they have adopted it. India also is offering open source and customizable digital programs or solutions, right? So this was this IIT, Triple IIT Bangalore support had been provided for Togo's some program that they had digital ID program of 2021-22, right? So that's there. Then co-development from transfer to collaboration. That's the idea. We have that e-Vidya Bharati, e-Arogya Bharati, tele-education and telemedicine. That's there. As I mentioned already, you have the UPI integration where you have roped in countries like Namibia, Ghana. That's being done. And long-term partnership, or should I say long-term institutional partnership, right? In fact, the ITEC training, Africa is the largest beneficiary, be it ICT, big data, governance, etc. We have been opening so many embassies in Africa, right? We have given over $12 billion of loans for ICT infrastructure, right? So that's there. So yes, plenty of information to write. And in fact, this is all rooted in the South-South cooperation, equal civilizational partnership, okay? See, and you can also contrast it to China and the West. Unlike China, there is no debt trap diplomacy, right? The emphasis is on empowerment of people in Africa. Or unlike the West, uh, so we have affordable alternatives, we have surveillance-free alternatives, right? Western tech comes with huge cost, and of course, this fear of consistent surveillance. India does not have that. So we don't trap you in debt. It's cheaper, it's affordable, there is no surveillance mechanism, it's meant for you, it can be curated for you. That's great. So that's all that you had to mention. Again, maybe on a difficulty level, I would say 6 or 7, depending on how effectively you have been covering IR. That's it. Okay, one more question, 10 marker. The last 10 marker question from IR was, with the waning of globalization, post-Cold War world is becoming a site of sovereign nationalism. See, of course, the contemporary global realignment is happening these days. Geopolitical disruptions like, say, the should we say US-China trade war, Russia-Ukraine conflict, the entire, that supply chain disruption because of pandemic, they have weakened the global economic integration, right? So waning of globalization. Okay. So yes, we have seen rise of nationalist policies. So MAGA, as we are witnessing firsthand, make America great again, America first, Brexit, EU protectionism, border securitization, etc. So this is all what? This is all signifying political reassertion of sovereignty. In fact, we also are following something like, say, Atmanirbhar Bharat. What is that? We are engaging selectively with globalization, but we are consistently forcing people here to have some kind of strategic autonomy models, right? So we are doing the same thing, okay? And we have seen so much of discourse happening on deglobalization, re-sovereignization, which dominates the contemporary IR or relations, right? Globalization has failed. I think recently, one PM of a country, UK, I think he had mentioned, Stammer, that globalization has failed. So yes, this requires a lot of linkage of information. I would give it a rating of 7 to 8 on difficulty level. It is slightly difficult. You have to understand the post-Cold War globalization, the, should we say, neoliberal globalization trajectory also, and its decline slowly and steadily. Then the link to nationalism has to be established, with the focus being on economic sovereignty, especially in the recent context of what India has been experiencing consistently, right? Thankfully, India could not be arm twisted. That was the expectation, that India would succumb to pressure, but we don't respond to stupid comments anyway. And that has been a great thing about the government, that they have maintained complete aloofness and indifference to any kind of stupidity coming in, whether it was something as silly as that India's forex, whatever reserves that we have, dollars, can only be spent based on US command or US authority. That is just a way to provoke a response from Indian government. And thankfully, the current dispensation has a better diplomatic approach, right? So that's there. So in this light, I would say we have to talk about, the unipolar liberal order, that end of history moment that happened with the collapse of Soviet Union, then the Washington Consensus that happened. So yes, we have had also a waning globalization, slowly structural breakdown, trade slowdown, supply chain weaponization, US China trade war, a tariff disruption. What is that? Supply chain weaponization. That's it. Sanction regime that the USA have been imposing, which India is also, or India was also being arm twisted, which resulted in the tariff war, or tariffs being imposed on India, was what? Just one way to end those ties. We have decades old interdependence that's being ended. And yes, pandemic did play a very important role in exposing the fragilities existing in a lot of leading countries. A lot of leading countries had to immediately prioritize on domestic production capabilities. That was it. So yes, we do have systemic contradictions. Inequality explosion is there, democratic deficit is happening, financial instability is there, and we have experienced a rise of economic nationalism. Let's be very clear on that. There is no denying this fact that we are experiencing something called economic nationalism, protectionist policies, Trump tariffs. Think of India also following something called the PLI, the production linked incentive scheme. What is that? The carbon border tax in EU. What is that? That's the same thing. Industrial policy revival is happening in strategic sectors. We are protecting our sectors through subsidies, local content requirement, right? And then we are trying to also restore the supply chain. So that's also being reshored now. Companies are relocating production closer to home markets. So that's there. And you can have examples of Brexit, you can have examples of MAGA, etc., thrown in to comprehensively complete the answer. That's it, right? So this is what you have to mention. We can add more points, like, this, I would say, dialectical relationship has become very, very complex now. Nationalism is using globalization, right? Selective integration, nations choosing beneficiaries or beneficial aspects, I would say, while asserting sovereignty. And then we also have seen something called digital nationalism, using global internet for domestic political mobilization. So yes, that's also there. Then we have come up with something called, I would say, a regional hybridization, the ASEAN model, economic integration, respecting the political sovereignty, or the BRICS cooperation. I mean, would you have imagined that China would have spoken in favor of India? Of course, unthinkable. Though, just to clarify, let's never have full faith in China, on China, but that came as a surprise. So yes, we do have some kind of regional hybridization also happening, South-South partnerships, which are challenging the Western dominance. Right? So that is why we say this is all variable geometry, different integration levels based on national priorities. Okay, which ultimately has weakened what? International system. WTO paralysis is happening, climate negotiations are in deadlock, pandemic response was very, very fragmented. Okay, so mention all these points and you are good to go. Sufficient. Again, as I said, this question largely tests the understanding of, I would say, the most significant shift in contemporary IR, the retreat from what we saw as liberal globalization towards various forms of nationalist governance. So I think this would be very important, essential knowledge for future diplomats, future policymakers. You are going to ultimately navigate this very transformed landscape. We all grew up talking about globalization, and now suddenly this shift, we have to understand it. So pretty logical question, I would say, in this regard, right? Okay, let's now quickly move on to the 250 word 15 marker questions. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. In the view of above observation of the Supreme Court, explain the concept of constitutional morality. I hope you remember your notes. What is the meaning of this phrase? This has been asked earlier as well in UPSC mains, right? And its application to ensure balance between judicial independence and judicial accountability in India. See, I would say uh, the biggest of all, of course, would be those the concepts of landmark judgments, whether you go as far back as Keshwanand Bharti of 73 or something, say the Navtej Singh Johar case, or even the striking down of this entire concept of NJAC, which was seen as a threat to judicial independence, right? So though it has triggered these debates that would say of collegium transparency, judicial recusals, etc., but that's there, of course. So this was the context, and in the recent times, Justice Yashwant Verma controversy, judicial conduct being questioned now. That's there. In fact, one Justice Pardiwala, who will be the future Chief Justice, look at a lot of his statements and a lot of the statements he has made. He had to backtrack on those orders, be it the order with respect to, should I say, reprimanding a High Court judge of Allahabad High Court. That was also taken back, or something as simple as the order on stray dogs that had to be reversed. In fact, very harsh opinions by Pardiwala, Justice Pardiwala on reservation back in 2015. He had to take those back as well. I think he has been taking back a lot of things that he has been saying. Anyway, so the idea is that constitutional morality. So first step, we'll have to understand and define this Ambedkar's conception of constitutional morality. So what is that? The idea is, what is this concept of morality, or I should say constitutional morality? It simply means adherence to the core constitutional principles like liberty, equality, fraternity, justice. So we have to follow these over popular whims, over majoritarian impulses, I would say. As Ambedkar said, that we have not seen a standard rule book of sorts. It's going to be a tough task. We'll have to inculcate these values, the essential core concepts of the Constitution. In fact, Justice Chandrachud had also mentioned this, right? That constitutional morality as the soul of the Constitution, requiring reverence for these values over even our personal beliefs. We have seen there have been so many judgments where Supreme Court has said that this morality is the guiding principle, ensuring constitutional functionaries act within the spirit of the Constitution. In fact, we say to every aspirant that every aspirant has to align his or her values with the values of the Constitution, right? So it will act as a check, right? How as a check? Something as simple as dual application for citizens also. Mob rule, no mob rule. We have to protect minority rights. It goes against the tyranny of majority. And also for high functionaries, right? Ensures that the actions of high functionaries is aligned with the ethos of the Constitution rather than your personal interest, your professional interest. So it has, I would say, dual application, right? That's it. Then Supreme Court observations, maybe something as simple as Navtej Singh Johar judgment, of how they protected the sexual minority, preventing social prejudices. Or also think of it, the very famous 2018 Supreme Court judgment in the Delhi NCT of Delhi case, where Supreme Court said that, see, the real head is actually the chief minister, not the governor, right? Purposive interpretation of the statements mentioned in the constitution. You have to also understand why a particular statement is mentioned. Okay, then we have to also have independence plus accountability framework, very very important. So we have guaranteed independence. How have we guaranteed it? Maybe through protection given in the constitution by appointment, security of tenure, difficult process of removal, fixed salaries, charge expenditure, right? All these things. Also, we need to ensure accountability mechanism, impeachment process. Though, I mean, no judge has ever been removed so far. Let's see what happens in this case, Justice Yashwant case, if anything happens. But so far, not a single judge has ever been removed through this process. So yes. Then judges, the courts also have some in-house procedures, internal disciplinary mechanism for minor misconduct that does take place. Then asset disclosure, judges have to disclose their assets to the chief justice, right? That transparency. So judicial conduct codes are there. Though we do not really have any standard, I would say, judicial standards bill, but still. So towards the end, you'll have to talk about, those simple issues, the, I would say, contemporary tensions, like say collegium being opaque, then consistently post-retirement jobs, that's also there. And then recusal standards. Recusal standards are not very, very clear, right? Highly subjective. Inconsistent practices. I mean, we have to avoid conflict of interest at all costs. It violates the very first principle of natural justice, right? But still, there is no set principle. So yes, we'll have to mention some case judgments. You have to mention the older judgments. Also, you have to mention about how judges. Now, this might not go down well with a lot of people, but Justice Chandrachud had mentioned this: judges as servants, not masters of the constitution, right? Because you are guided by ultimately the essential values, the morality of the constitution. Though nowadays Justice Chandrachud is highly hated by both sides, the right and the left. But anyway, but what he said in this regard was absolutely correct. So that's there. And then we can, towards the end, mention some reforms, especially the collegium. There should be some kind of structured oversight mechanism, some kind of ethical framework, codified rules, etc. Judicial training programs, regular training programs on the values for judges, that should be there. There should be ethical guidelines, right? We also have to prevent excessive use of 142, something that we have seen in the in the governor's bill case of Tamil Nadu. What was that? That was a very inappropriate use of Article 142. A two-judge bench in the garb of Article 142 is trying to interpret the Constitution. That is not a fair assessment, right? Let's see what Supreme Court's reference is going to be in this regard. But then, yes, and it is not that it is not mentioned in the Constitution. Article 145, Clause 3 very clearly says any bench whose task is to interpret Constitution should comprise of at least 5 judges. A two-judge bench simply has no authority to give such diktat to the governors and impose such orders. In fact, they have gone ahead to pass bills, right? We did see this happen in the case of Manipur as well in 2020 in the Keshav Meghchand Singh case, where Supreme Court removed a minister. Of course, that made sense there because of the problem of defection. So, but then where do we draw the line? That's very important, right? So judges have to refrain from populism. Okay, protection of judges from succumbing to populist pressure, majoritarian sentiment, and also if you observe what has been happening against judges as well, that these groups, whatever group you belong to, if a judgment comes in your favor, you are happy that, oh, great judge. As soon as the judge questions your value system or gives a judgment against you, then you are pretty unhappy about it. And that is not fair. We have to also be more rational. As I said, the dual application. So morality acts as a check on citizens, on people, as well as the high functionaries authorities. Okay, so not a difficult question. Again, the idea was to explain or rather check the understanding of how abstract these abstract principles, or should I say abstract constitutional ideas, translate into concrete institutional governance mechanisms, right? Again, something which is very important for the future administrators, right? Because you have to navigate this very complex relationship between independence and accountability for every, not just judicial, for every democratic institution. Yes, we want independence, but what about accountability, right? Okay. The next question. Indian Constitution has conferred the amending power on ordinary legislative institutions with a few procedural hurdles. Okay. In view of the statement, examine the procedural and substantive limitations on the amending power of the parliament to change the constitution. Straightforward. Nothing beyond Article 368 and Keshwanand Bharti. So this is a question on basic structure and Article 368 provisions. What are those meaningful limitations? What are the procedural limitations? Will we mention the procedure? Yes, you have to mention Article 368 procedure. You have to also mention about what kind of majority is required. What if uh, the provision or the bill seeks to amend the federal structure? Then what is required to be done? In that case, what do? In that case, you have to also take the approval of at least how many states? Half the state, simple majority. But then you have to mention those things, right? Apart from it, there are other ways to modify the constitution. A lot of things can be modified by law by a simple majority. And then let's not forget the most important one, the substantive limitations, the limitations imposed by judiciary. So what is that? The limitation was imposed by in the Keshwan Bharti judgment that certain features, certain essential values, core values cannot be taken away. Uh, Constitution is a supreme law, etc. All these things, right? So mention examples there as well. Now, see, why would this question be asked? If we have to actually pinpoint on that, I would say recently so many amendments have been challenged. In fact, you see the 129th amendment, which is on one nation, one election, or the newly introduced 130th amendment, which we are not really sure what the government is trying to do. Because why take this risk? I mean, the entire opposition is against this amendment, though it's a very logical amendment to make. But despite not being in a majority, I don't know why the government has brought this kind of bill, because amendment bills under Article 368 require a two-third majority, right? Interesting. So, is the government looking for a midterm election? Possibly, we don't know. Uh, because a lot of people do believe that if we have elections right now, this ruling government might get back to the 2019 situation of more than 350 seats collectively, not individually, collectively as a ND. That is possible. So we don't really know. But again, the point is so many amendments are being questioned, are being challenged, etc. So yes, a very logical question to seek, especially in the context of this ongoing debate of parliamentary sovereignty versus judicial review that has always been there. So a question every 3-4 years, you will find a question on basic structure in a different format. This is that very question. I won't say difficult at all. This would be on the easier side of things, 5 to 6 on the rating of difficulty. That's how it is. So yes, you can mention all the famous judgments, including I.R. Coelho, Keshwanand Bharti, the reservation case of 2022, etc. Everything. Minerva Mills case, the very famous judgment of 1980, which gave judicial review as a part of basic structure, right? So all things can be mentioned. Some kind of criticism on how it is curbing the authority of the parliament. But again, we have to also look at the positive side on how parliament's power to modify is not an absolute power, because any authority which gets an absolute power, of course, directly violates Article 14 as well, rule of law. So that's also there. Summarizing that, I think this would have just one concern, and the major concern is having a more broader defined criteria for basic structure. Nothing beyond that is a big concern, right? And yes, again, safeguards as far as the judicial limitations are concerned, which are there. I mean, if you just have a look at how many amendments has judiciary cancelled in the last, say, 30 odd years, one, that is a 2014 one. Nothing that comes to our mind. Any constitutional amendment being cancelled, being struck down. So it had the courts have ensured very refrained use, judicious use. So we don't really see that as a problem, frankly. That's how it is. Mention that in the concluding remark as well. Okay. Next question, discuss the evolution of collegium system in India, critically examine the advantages and the disadvantages of the system of appointment of judges of the Supreme Court of India and that of USA. Simple, straightforward. I mean, I cannot give it more than 4 in the rating of difficulty. This is as straightforward as a question can be. All the judges' cases. See, recently we have seen a lot of issues, the tussle between the Ministry of Law or the government versus the judiciary. We have seen so many recommendations. I would not say so many, that's a far-fetched statement to make, but a lot of recommendations were kept pending in the court with the government, recommendations for appointment. So yes, we have seen this tussle. In fact, Ministry of Law, the Minister of State had made a statement also that collegium system is opaque, right? Nishikant Dubey had made so many statements on judiciary. Uh, the the recommendation of Saurabh Kirpal raised a lot of concerns on allegations of nepotism. So yes, nothing difficult, right? And comparison to USA also ensures that we understand what was the system in USA. So here you have to mention about the evolution, the first judge's case, SP Gupta case, the second judge's case, where finally the concept of collegium saw, or the seeds were sown very clearly, and then how it got finalized in 1998, the presidential reference case. We had to mention the NJC Act also, how the Parliament did try to intervene, but nothing could come out of it. That's also there. And then finally, some, of course, advantages and disadvantages of our system compared to USA. So a better thing would be to draw in a table. So in USA, what is the appointment process? Very simple, straightforward. In USA, the president appoints the judges, and of course, yes, with senatorial confirmation. Senate confirms it, but no retirement age, no appointment age, no fixed tenure, nothing. I mean, the current Chief Justice of the US Supreme Court has been in office since 2005, 20 years. He has been in office, right? So that's there. In USA, since the Senate approves it, so it's more transparent. Elected branches are involved. So ideology, suitability, debates can take place in the House while approving a judge's name. But there's a lot of politicization also, right? Because depending on how the House is shaped, liberals versus conservatives, then we can have those kind of judges who have certain ideological leanings getting appointed, right? And the judicial decisions will also reflect this kind of partisan divide, which is not there. And then what if the Senate refuses to approve? Then yes, the vacancy will continue. So that's the difference. In India, we prioritize judicial independence. So it suffers from the very simple problem of being opaque, complete opaque system. USA prioritizes on accountability and legitimacy. So it suffers from politicization. Both are struggling to balance independence, accountability, and transparency. It's a very tough nut to crack for any country, right? And the idea should be in your conclusion that we have to somehow marry independence with accountability, right? Maybe you can again go and mention in the concluding remark that we have to go back to NJAC. It must be revived, right? Maybe, of course, in a reformed format. I'm not saying the same NJAC, because executives' interaction with judges is not healthy at all, especially in a context where more than half the cases in the court which are pending are against the judiciary. And that is not fair, against the executive, the central government. So that's not fair. So yes, maybe not the law minister, maybe have a more defined criteria for eminent jurist. That would maybe seal the deal for the courts as well. And courts have to also accept some kind of check, because I mean, you see here the system of judgments don't seem to be that great, right? When consistently lines are being blurred, activism becomes overreach, we are looking at judges being adventurous, being populist, etc. They also reflect whims and fancies, and as Ambedkar said that um, the chief justice or any judge is beyond uh, question is a very wrong idea. I mean, no human being is beyond bias or beyond mistakes. So are the judges. Okay. But again, a very straightforward question. So I don't see any special problem as such in answering this question. So simple. The design idea of what is the system of appointment in India, USA, the collegium system, etc. Straightforward, right? We were actually expecting a collegium question for such a long period of time. Finally, the UPSC has obliged the innocent aspirants into looking at this or giving them this question. You can vomit to your heart's content about all things you know about the collegium system. Then we have a question on the center state financial relations in the context of planned development in India. So, examine the evolving pattern of center state financial relations in the context of planned development in India. How far have the recent reforms impacted the fiscal federalism in India? So, especially with the 106th Finance Commission, uh, uh, 16 Finance Commission deliberation, right? That was there in 2024 last year. So under tax devolution, right? And we have seen consistent remarks being made by a lot of these states like Karnataka or Tamil Nadu, etc., on the horizontal horizontal distribution formula, right? So that's there. Then the GST regime complications, compensation, the cess problem, right? Center is relying on cess, revenue sharing concern. In fact, COVID-19 fiscal stress, states demanding higher borrowing limits, um, enhance fiscal, I would say, flexibility. Those states don't realize that they're wasting resources also on the freebie game that every state has now gone down to, and every party. So we'll have to give credit to Aam Aadmi Party for teaching the politicians that the only way to win a heart of an Indian is to give things free of cost. We love things free, right? Buy one get one free, 90% discount, great. Say on cost price, mark price, useless. Increase the price, make a product of 50 rupees, market as 1000, give 90% discount, sell for 100, great. Directly sell for 70, nobody purchases it. That's a problem. And so we love freebies, right? And I think Mr. Kejriwal cracked the code that we love freebies, and every party is following it now. Congress, BJP, they had been claiming that no, we won't follow the freebie game. You are doing it now, and your state, wherever you are in, is under a lot of strain. Be it Karnataka, be it Punjab, you'll see this shortly happening in Maharashtra, because the states simply don't have the financial capacity to run freebie schemes like this, right? Anyway, so yes, this question required a lot of information, so we have to at least rate it on a slightly more difficult side. I would say 7 or possibly 8 because of linkage. So it requires strong historical perspective, no, evolution from the planned economy to the market oriented federalism, then integration of some recent reforms like the GST Council, Niti Aayog, Finance Commission, FRBM relaxations also. You can add that as well, right? A balancing theory, I would say, constitutional federalism, and also political fiscal tension, right? So that's a balance between theory and practice. And yes, as the second part also says, how far have the recent reforms, interaction or other integration of current affairs events also. So there you have to mention about how, in the planned development phase, so rather we would say in the phase of 1950 to 2014 phase, in this phase, how we had the central dominance, right? resource allocation control comprehensively, dual transfer mechanism. Finance Commission was handling the constitutional transfers. Planning Commission was handling all these plan assistance, dual dependency. And then state autonomy was highly limited. States responsible for 60% of developmental expenditure are collecting only 37% revenue, right? Please go and have a look at the stateless subjects. Health, education, agriculture, industries, trade and commerce. Of course, you can claim, but the industries also are also in the union list, but it is in the state list as well, right? In the union list, you have industries and mines and minerals, but only for extreme cases. But something like trade and commerce, something like mines and minerals, industries, these are all stateless subjects. Such burden of performance and expectation with limited revenue, of course, a concern, right? And then finally, the planning commission era ended, right? So this conditional transfer era ended finally. And then although we can also add one more point, the finance commission's very constrained role, early finance commission, like the first, second, third, till I think sixth and seventh, they focused primarily on addressing the fiscal gaps. They did not promote genuine autonomy, and very modest tax devolutions were being followed. States' share in central tax, I would say, was around 20-25% during the initial decades. That's there, which also brings to us the point of very limited horizontal equity, right? Distribution criteria favored general needs, not performance needs, right? So it did not focus on developmental outcomes. It focused on basic needs. Now, post 91, we saw a gradual shift. So, see, you have to divide this also. Pre 1991, post 1991. That also needs to be mentioned. Very important. So, market economy impact has been there. Reduced plan significance, right? Economic liberalization has diminished planning commission's resource control because market mechanisms gained prominence. Then, in economics, you must have covered FRBM Act of 2003. That needs to be mentioned here. That's why I said this is not an easy question to mark in case you want to comprehensively address all aspects, right? And then came the state competition, because once we had opened up our doors to investment, states started competing for private investments. If you remember how Gujarat offered a project which was initially going to go to West Bengal, a very classic case, right? So states started competing for private investments. That also meant implementing state-specific reforms, state-specific policies. And then we saw the enhanced role of Finance Commission. I think from the 8th Finance Commission onwards, you see it gained importance, especially with respect to resource distribution. That was a very important criteria. Then we also saw progressive devolution. States share gradually increased, 29%. Then in 13 Finance Commission, it increased to 32%. Okay. Then even the criteria for devolution or horizontal distribution, it also saw an evolution. Areas or topics like um, forest cover, fiscal discipline, alongside population and income distance, we saw all these areas also being covered, right? So, and then 2014 onwards, we saw the Planning Commission being abolished, Niti Aayog being created, replacing the Planning Commission with this advisory body without any grant giving powers. That was a big turn of events, right? So we'll have to mention that as well. Then the 14 Finance Commission, the 14 Finance Commission increased the state tax devolution to an unprecedented level, 32%, 42% jump. That was a 10% jump, right? And then we had the compensatory mechanism, higher devolution compensated for, because we had the Planning Commission transfers no longer existent because the body was removed. So we had to also have compensation mechanism. And then state share increased drastically. So we have to mention all these things. Then in 2017, the GST implementation has to be mentioned, the cooperative federalism platform, the 101st Amendment Act needs to be mentioned, the GST Council formation needs to be mentioned. So as I said, and in case you want, you can also mention in one line the voting structure, right? Center's weightage and states collectively weigh 2/3, right? So states' voice is also a part of decision making. You see how this reflects very clearly. And then Supreme Court decision that came in 2022 that GST Council recommendations cannot be binding and all. You can add that as well. Then 15 Finance Commission slight reduction from 42, 41% devolution now. And then COVID response can also be added. So a lot of things can be incorporated if you want to. Right? So it's not an easy question to answer, frankly. Right. So the idea is that, to conclude, I would say, of course, there will be some challenges like the vertical fiscal imbalance will be there. GST implementation, that reveals a lot of tension between the cooperative ideals, right, and practical governance. Those are two different things. So yes, a comprehensive question that needs to be addressed, and this did test a lot of knowledge of the student collectively. So a very challenging question, so as to say. Okay, and then I think we have the two questions from IR, the 15 markers, standard 50 marks questions from IR, two 10 markers, two 15 markers. Energy security constitutes the dominant kingpin of India's foreign policy and is linked with India's overarching influence in Middle Eastern countries. How would you integrate energy security with India's foreign policy trajectories in the coming 15 years? That's a very interesting. I mean, we can now sit and say interesting, but imagine the plight of an aspirant who is looking at this question says, now, how would you integrate security with foreign policy trajectories in the coming 15 years? You're asking me to make policies on the spot. Extremely, I would say, a challenging question in the exam. See, frankly, why would this concern be raised? So look at contemporary energy geopolitics in the country. India is actually importing 85% of its oil, largely from Middle Eastern countries like, say, Saudi, Iraq, UAE, Qatar, Iran, whatever, right? In fact, this kind of, energy security is also critically dependent on regional stability. And then we always experience geopolitical disruptions, Russia-Ukraine war, the Red Sea shipping crisis. So it sometimes does create those supply chain volatilities, pricing pressures. And then we have had some strategic initiatives also, the strategic petroleum reserve expansion, the green hydrogen mission that we had, the I2U2 grouping that we have, that's also there. In fact, Middle East has also gone through a transformation, the Saudi Vision 2030, right? UAE's green energy investments. So they are, in fact, offering diplomacy, I would say, or partnership beyond the traditional hydrocarbons, right? So I would say anywhere from 7 to 8 would be the difficulty level of this question, right? So you have to integrate international relations with energy economics, with future strategic vision. So beyond the oil dependence thinking, demonstrating the understanding that renewables, maritime security, right? Not just those, but also things like the renewables, things like maritime security, they all need to be incorporated, right? Strategic autonomy. So this question seeks a forward-looking trajectory, I would say, spanning 15 years, right? So see, I would say the integrating framework for the next 15 years is very simple. Or should we say integration framework, a better word. So the context is energy as foreign policy cornerstone. So of course, the strategic imperative would be energy consumption projected to grow from around 6% to 10%, etc. All that data can be put in. Beyond that, I would say Middle East centrality, right? The region also hosts around 9-10 million Indian diaspora. That is also generating over upwards of, I would say, $40 billion in annual remittances. Let's never forget that, right? So, in fact, energy trade worth hundreds of billions is also annually creating mutual stakes in stability, right? Then short-term hydrocarbon security can be looked into, supply diversification can be looked into. Then we can have some medium to long-term energy transition partnerships, maybe renewable energy diplomacy, the ISA, International Solar Alliance. So that can leverage the 121 member platform, right? Middle East capital, especially for global prospects. That's also there. Then the I2U2 I2U2 is India, Israel, UAE, US, 4 countries. I2, U2. So that cooperation on the clean energy technology, investment, green hydrogen economy, joint ventures with say, Saudi, joint venture with UAE for production, for storage, for export infrastructure, right? Then we can have a technical or technology collaboration. Let's use this word. Joint R&D initiatives in solar manufacturing, wind technology, energy storage, right? So all these things need to be incorporated, right? So yes, then some kind of investment integration, to I think the gift city operations, etc. That can also be mentioned. Maritime and strategic security dimensions, critical choke point protection, the Strait of Hormuz security, right? See, 40% of global seaborne oil transit requiring multilateral security cooperation. We can put that in, right? Indian Ocean dominance. See, strengthening the naval capability is very, very important. And maybe partnership that can ensure secure energy lanes, then infrastructure connectivity. We can have the multilateral security frameworks, quad cooperation, right? Secure sea lines with US, Japan, Australia for energy security, right? Then we can have the regional maritime security initiative with the GCC, the Gulf Cooperation Council, Indo-Pacific energy security architecture. So a lot of things can be incorporated as a part of your answer. And of course, let's not forget the diaspora and the soft power leverage, right? Cultural diplomacy, something as simple as the Yoga Day celebration, Indian festivals, strengthening people-to-people ties, education partnerships, technical training programs, maybe that can also be a part. Um, Crisis management, Operation Rahat, Operation Kaveri, that has demonstrated India's regional stabilization capacity and also intent, both. So yes, in fact, Vision 2040 should be we move from being a consumer to being a partner, from consumer to partner. Energy self-sufficiency, uh, technology leadership, and regional energy hub, facilitating energy trade between Middle East, South Asia, and Africa. That's the idea, right? So yes, a lot of things to incorporate, a lot of ideas to mention, and yes, this a better way would have been to divide this 15-year into a 5-year gap and mention or address the points likewise. Okay, that's there. And finally, the last question that we had from IR is this. The reform process in the UN remains unresolved because of the delicate imbalance of East and West and entanglement of the US versus Russo-Chinese alliance. Examine and critically evaluate the East-West policy confrontations in this regard. See, the IR questions this time were not that straightforward. As we say, this has become a thinking person's paper. See, UN at 80, reform debate has been gaining a lot of momentum, especially with these G4 nations, us, Japan, Germany, Brazil. They are pressing for the UNSC expansion. In fact, African Union admitted to G20, right? That's a momentum for, we should say, global South voice in the UN structures. Ukraine war is a classic case of UNSC's paralysis due to Russia's veto use. Simple, right? In fact, we have faced so many problems with respect to China's veto power, right? Then the US-China rivalry, surprisingly, Russia-China alignment. In fact, it has also blocked a lot of consensus on reforms. In fact, Security Council expansion blockage comes from these countries only. They don't want to expand. So yes, a difficulty level slightly on the higher side, but nothing that we did not expect is my point. So UN reform debates, UNG resolutions, the panel reports, maybe, right? Then the current power confrontations like say US versus China, Russia versus West alignment, India's role, the G4 initiative, right? We also have this East-West rivalry angle. So don't mention that UN is outdated. UN is not outdated. Don't write that generic statement here. See, UN reforms has been stalled since 1990s. They are trapped in this geopolitical gridlock, I would say, between East, that is Russia, China, and now India as well, and the West, USA, Europe. And I would say this institutional paralysis, it reflects deeper. I mean, because see, the great power competition keeps on happening, and the deadlock comes from West also. We have seen how US, UK, France rhetorically are supporting India, but when it comes to veto privilege, they want to protect their own veto privilege. This drama that yes, we want India, Japan, and Germany, that's only rhetorical, right? At least China is very clear. China clearly systematically blocks India and Japan because regional rivalries. Russia backs India, but conditionally, Russia opposes Japan. So all these five countries are very well aware that they have created these silos amongst themselves to keep others out. As simple as that, right? So yes, that's a concern. In fact, as I said earlier as well, Ukraine's war paralysis is something that you need to mention. UNSC has been reduced to West versus Russia battle, or rather, should we say veto battle, right? So that has exposed the institutional dysfunctioning. And why are reforms stalled? As say, of course, P5 privilege. No incentive is there for say USA or Russia or China or UK, France to dilute veto power. Tell me what is the incentive for them to expand membership? Nothing at all, right? And the East-West mistrust continues. It is not that it has been resolved. So fundamental changes, any kind of consensus is impossible. In fact, see, G4, L69 groups, they all demand expansion, right? Uh, but uniting for consensus, no. Imagine countries like Italy, Pakistan, they're also opposing some members of G4. So that's also there. It's not that we are getting support from the other countries. Some countries are opposing us as well. Of course, our best friends, Pakistan, will always oppose us. That is their bread and butter in life. Then India's position should be mentioned. India is calling for the multipolar. The multipolar world is very clear, and UN should reflect the contemporary realities, especially for India, largest democracy, 1/6 of humanity, right? Major peacekeeping contributor. It aligns with G4 partners, African Union's consensus also. So it's like uh, India has a very strong contention here. Okay, so you'll have to, in the concluding remark, also mention how this entire structure of UN remains hostage to the great power rivalry, especially between East and West, especially between China, Russia versus EU, USA, and that has overridden any kind of institutional effectiveness. That's it, right? So see, in this, I do not really see major challenges except quoting different things and avoiding generic, UN reform essay type information. You have to mention the UN, the USA versus Russia, China bloc dynamics, how India is playing its role, etc. So larger linkage is what is required. That's it. Nothing beyond that is required. So that was it. Uh, just to before you end, one small point. So one bonus question for you. This question was put in paper one. UPSC is UPSC. As we say, UPSC कुछ भी कर सकता है. It's UPSC. So I don't know why they put this in paper one. It is a classic paper two question: role of civil services in a democracy. The ethos of civil service in India stand for combination of professionalism with nationalistic consciousness. Elucidate. Elucidate is the idea of explaining, making something clear. This is a question from paper, right? So ethos meaning the guiding spirit, values, the culture. See, in India, the ethos has always been a blend of professional competence like efficiency, neutrality, integrity, and also nationalistic consciousness, commitment to unity, integrity, welfare of India. See, this question has been asked because, again, we have Mission Karmyogi now. It's in full force. The focus is on the professional, citizen-centric approach, ethical bureaucracy, right? In fact, recent debates have been there on politicization of bureaucracy, demand for a very nationalist civil service. You see, sadly, the books being modified and changed now. This will have an impact only after 30 years because the current set of bureaucrats, are largely working with a mindset that has been there because of the books they read, right? So what you might see as a more enhanced respect for the country's cultural conscience could be visible only after 20-30 years, sadly, right? Anyway, so yes, 75 years of independence, that's a reflection on civil services as the steel frame. Remember the steel frame, sorry, my mistake, the steel frame, this steel frame, not that steel frame. Okay, so that's it. See, I would not say it's a difficult question because we have these discussions going on, and especially professionality or professionalism is something that we directly discuss, right? So one is the professional component, competence, expertise, merit-based recruitment, right? Rigorous selection criteria, then impartiality, neutrality, that's also being discussed as a part of your role, integrity, accountability, efficiency, effectiveness, right? And then we have the nationalistic consciousness component also, where we need to have a constitutional patriotism, unity, integrity, service before self, developmental nationalism. So yes, ultimately you have to in this question mention the synthesis and balance. See, Sardar Patel's vision of IAS as a steel frame, or Dr. Ambedkar's conception of civil service as forming a protective ring around the constitution, right? And as we say, it has also been, it is witnessed in the contemporary manifestations like Mission Karmyogi, a very, very popular mission to train our civil servants, right? Then de-civilization, breaking those departmental barriers, maintaining professional standards, digital governance. And see, combination is very crucial. I would say, I'll tell you why. Professionalism alone, a very cold technocracy, completely disconnected from the grassroots reality in society. Nationalism alone, emotional zeal, but risk of inefficiency, politicization. Together, both together will give you the idea of competence, commitment, servants of the constitution concept. So yes, that's what you had to mention. I don't see any such problem in this question that you would face difficulty of not more than 4 or 5, let's say 5. So a healthy mix of difficult and uh, easy questions, right? So that was it as far as our discussion is concerned. Hope that you were enlightened by this discussion, at least to some extent, right? And let's meet in some other video. Till then, that is going to be all for me. Jai Hind.